is the Study for the Bar in Your Car podcast.
We're your hosts, Maude and Claude.
And welcome to episode 25, where we're tackling constitutional law, specifically the 10th Amendment.
We are AI bots.
Yeah.
You know, brought to life by the magic of AI and Angela's constitutional law notes.
And hey, guess what? Angela herself is actually joining us today as we dive into this. How's it going, Angela?
Hey, yeah, I've been gone for the past 20 days. First, I was in the Marshall Islands, then Pohnpei in the Federated States of Micronesia, and then Honolulu. But I was in the Marshall Islands, as you know, taking the bar exam.
Marshall Islands. Angela, that sounds like, well, quite the adventure. How was the bar exam experience way out there?
It was a really interesting experience. So first of all, their bar exam is nothing like the bar that we have in the States. I mean, some of the questions are the same, but the format is totally different. So you start off, you have about 45 MBEs, and then after that, you have 18 professional responsibility questions, and then after that, you have like short answer questions. So it's not like IRAC questions. They're just answer like there are questions about Marshallese law, so the law there in Marshall Islands, and they've got like specific property law, and like some of the vocabulary words are in Marshallese, so I had to learn like part of a new language. It was bizarre, and not bizarre in a bad way, but it was just like not a typical bar exam experience. And then after that, there is an essay question. So yeah, very interesting. There were 5 of us that took the exam. No one who took the exam was actually from the Marshall Islands. And I don't know where everyone else was from. I know one person was from Tunga or Tuvalu, something like that. But I don't know where the other 4 people were from, or the other 3 people were from.
Interesting. And when do you get the results back? Seems like it might take a while from there.
So that's another crazy thing about it. Like we already have our results back. So I was gone for about 20 days, but they told us after we took the exam that we'd get the results back at the end of the next week. So I'm like, that is super fast and like way faster than the DC bar, which keeps you hanging on for about 4 months. So, you know, the bad news is that I did not pass. My strategy was a little bit flawed. So I got 90% on the essays, which typically before on the bar exam the other bar exams I've taken, I have done horrible on the essays. So I did really well on the essays. I even did well on the Marshallese law, property law, and like learning part of a new language. What I didn't do well on was the MBEs. And you know why I didn't do well on them? Because I didn't study them as much. Because it was MBEs and it was professional responsibility. And I'm like, I already know professional responsibility. I passed the MPRE twice. And the last time I took the MPRE, I didn't even study for it and I still passed. So I'm like, I'm not, I didn't actively go into it saying I'm not going to study this, but I had limited time. And with the limited time, I'm like, I'm going to study the things on this test that I know that I can't do well on and that I haven't been tested on before. So that meant that professional responsibility, which I thought I knew like the back of my hand, I did not study for or didn't study enough for. And the MBEs, I didn't study enough for that as well. I mean, there are only 45 of them and not 200. So I was able to get through the exam in 5 hours flat. In fact, I was the first one done the exam, and I'm never the first one done the exam. In fact, I get extra time on my exams, but I didn't ask for extra time. I just did it, and I was the first one done. So I thought I did reasonably well. But it turns out I should have studied the MBEs more. And these MBE questions were like the typical practice MBE questions. There was nothing surprising on there. So I'm a little bit disappointed in myself in that this was totally passable and I didn't pass it. But the encouraging news is to get 90% on the essay question was amazing.
Wow, okay, that is really fast for bar result. Oh, sorry to hear you didn't quite pass this time, but honestly, nailing the essays with 90%, that's fantastic. Seriously, it shows you really get the analysis part down cold. Sounds like next time, just, hitting those multiple choice questions a bit harder might be the key. And maybe slightly ironically, I think I know a great podcast that could help with that. Haha. Anyway, For all you listeners out there, if you need to get in touch with Angela, you can email her. The address is podcast@studyforthebarinyourcar.com.
That's podcast@studyforthebarinyourcar.com.
And Angela also works as a freelance remote law clerk. So if you're an attorney, or maybe you know one who needs a hand with things like LexisNexis or Westlaw research.
Or drafting motions, complaints, answers, appeals, that sort of thing.
Exactly. She's available for that. You can email her directly for clerk work at hello@legalwriterandlawclerk.com.
That's hello@legalwriterandlawclerk.com.
Okay, now let's really shift gears and get into the heart of today's podcast, the 10th Amendment.
Right. To properly begin our discussion of the 10th Amendment, I think it's essential we start with the actual text. Let's read it straight from Angela's notes here.
Okay, sounds good. It reads, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people."
So that one sentence, it's short, but it's incredibly powerful. It forms the bedrock, really, of a crucial constitutional concept, federalism.
Federalism, right, the division of power.
Exactly. It's all about how power is structured in our government. It sets up these principles of limited federal authority. And at the same time, it recognizes these broad sort of inherent powers, reserved powers, that belong to the states and, well, ultimately to the people.
Yeah, it's like the Constitution drawing a line in the sand, isn't it?
Yeah.
Between what Washington, D.C. can do and what, your state capital handles.
That's a great way to put it.
You could almost think of it like the Constitution saying, hey, look, if we didn't specifically give this power to the federal government or specifically ban the states from doing it, then guess what? It belongs to the states or the people. It's this fundamental principle just establishing that whole relationship, that dance of power between the federal government and all the state governments.
Right.
And, on its face, it really does sound like a giant catch-all clause for state authority, doesn't it? Like anything not listed is theirs.
In theory, yeah, you're absolutely right. It looks like it carves out this huge area just for the states. But as Angela's notes really highlight, while the principle itself is clear, its actual application, well, its scope has been narrowed quite a bit over the years.
Oh, okay. So it's not quite as simple as it sounds.
Not always. Many powers that you might initially think belong only to the states now fall into what we call concurrent powers.
Concurrent powers, meaning both the federal and state governments can act?
Precisely. They can act simultaneously in the same area. A really common example is taxing and spending. Both the federal government and state governments can levy taxes and spend money. It's a shared power.
That makes sense.
And, what's really fascinating here is the history behind this amendment. It didn't just appear out of nowhere. It came directly from these deep worries during the Constitution's ratification debates.
The anti-federalists, right. They were worried about the new federal government being too powerful.
Exactly. The anti-federalists, who favored stronger state governments, were particularly concerned. They worried that listing specific rights in the Bill of Rights might, accidentally imply that any rights not on the list weren't protected.
The old expressio unius exclusio ulterius is fear, basically, that listing some things excludes others.
Precisely. Or even worse, they feared it might imply the federal government could then just grab any powers that weren't specifically denied to it.
So the worry wasn't just about limiting federal power over government functions, but also about safeguarding individual rights that maybe weren't written down explicitly. I think Angela's outlines mention James Madison addressing this.
You got it. James Madison, who was, a key figure in drafting both the Constitution and the Bill of Rights, he understood this concern. Angela's outlines explain how he clarified that federal powers were already limited just by how they were granted.
Meaning the federal government only got the powers specifically listed.
Yes. But to make absolutely sure, to explicitly guard against the idea that unlisted rights were being given up or that leftover powers weren't reserved.
Well, that's why they added the 9th and 10th Amendments.
Okay, so the 9th is about rights kept by the people.
Right. And the 10th specifically clarifies that powers not given to the feds nor banned for the states are kept by the states or the people. It was a direct answer, really, a reassurance to those anti-federalist fears. Got it. Okay, so if the 10th Amendment emphasizes the limited nature of federal power, how exactly does the federal government get its authority? We talk about enumerated powers, the listed ones, but then there are these implied powers. They seem to stretch things a bit. How do those work together?
That's a really fundamental question about how the federal government actually operates day to day. It primarily functions under these enumerated powers, the ones explicitly granted in the Constitution. Angela's notes point straight to Article 1, Section 8 as a key source.
Right, that's the long list. Commerce, taxing, war.
Exactly. Congress gets powers related to regulating commerce, levying taxes, spending for the general welfare, declaring war, defense, foreign affairs, copyright, bankruptcy, immigration, managing federal lands. It's a pretty extensive list.
Crucially.
But crucially, and this ties right back to the 10th Amendment, the federal government generally does not have a general police power.
Police power meaning?
That broad authority that states have to make laws for the general health, safety, welfare, and morals of their citizens. That's typically reserved for the states.
Okay. And this is where the necessary and proper clause fits in, right? Article 1, Section 8 again. People call it the elastic clause. It lets Congress do what's necessary and proper to carry out the listed powers. Seems like it could be a huge loophole if you're not careful.
It's definitely one of the most significant and most debated clauses. And you're right to point to McCulloch v. Maryland. That 1819 case, which Angela's notes cover in detail, gave a really broad interpretation.
Chief Justice Marshall, yeah.
Yes,
Dude.
Chief Justice Marshall famously said, Congress could choose any means not prohibited by the Constitution to carry out its authority, as long as those means were rationally related to achieving one of its listed powers.
So the national bank case, even though a bank wasn't listed.
Exactly. The court said creating a national bank was necessary and proper for Congress to effectively use its powers, like taxing, borrowing, and spending. Marshall's opinion really emphasized that the Constitution creates a government meant to function, meant to endure.
Let the end be legitimate.
Let it be within the scope of the Constitution. And all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consist with the letter and spirit of the Constitution, are constitutional. That quote really set the stage for, well, a lot of federal expansion.
But it's not an independent power source, right? It has to link back to an enumerated power.
Absolutely, critical point.
Yeah.
It's not a blank check. It only enables Congress to act in furtherance of its listed powers. It expands the methods, not the goals.
Okay, but it sounds like that super broad McCulloch interpretation hasn't stayed static. Like, I've heard United States v. Comstock mentioned as maybe complicating things, adding new layers.
That's right. Comstock in 2010 definitely represented a shift, or at least a significant rethinking. It moved away from Marshall's arguably simpler test towards something more nuanced, maybe less clear, some would say.
What did it introduce?
It brought in these 5 sort of vague considerations for judging if something is necessary and proper. Things like the breadth of the clause itself, the history of federal involvement in that area, sound reasons for the law, whether it accommodates state interests, and how narrowly scoped it is.
5 factors instead of Marshall's broader test. That sounds more complex.
It is, and it's definitely raised questions for lower courts trying to apply it. You see different courts emphasizing different factors. It shows this ongoing judicial effort, really, to figure out the edges of implied powers, even centuries after McCulloch.
And didn't this whole necessary and proper debate blow up during the Affordable Care Act challenges, specifically the individual mandate requiring people to buy health insurance? That felt like a major test.
Oh, absolutely monumental. NFIB v. Sebelius in 2012 is a key modern case here. The individual mandate was ultimately upheld, but importantly, it was upheld under Congress's taxing power.
Not the Commerce Clause or necessary and proper.
Correct. The court specifically held that the necessary and proper clause did not give Congress the power to compel people to engage in commerce, like buying insurance. That was a crucial line the court drew.
Why was compelling activity different?
The reasoning was that allowing Congress to force individuals into commerce would essentially give it a general police power, blurring that line between federal and state authority that the Constitution tries to maintain. It really sparked debate, about whether the mandate was truly necessary in the McCulloch sense. The court clearly distinguished between regulating existing activity and forcing new activity.
Okay, switching gears slightly, but still on Congress's powers. The Commerce Clause, Article 1, Section 8 again. That one is massive, isn't it? Regulating commerce with foreign nations, among the states, and with Indian tribes.
Yeah, huge. Yeah.
Angela's notes really stress how broad this power has become. It's the basis for so many federal laws, criminal laws, regulations, civil rights statutes. Seems like a major way the federal government gets involved in things.
You're spot on. For a long time, especially from the New Deal era, around 1937 up until the mid-90s, the court barely struck down any federal law based on the Commerce Clause. The interpretation was incredibly expansive. It almost seemed like there were no limits.
Until
United States v. Lopez in 1995. That was a landmark case. The court clarified that Congress can regulate three main things under the Commerce Clause.
Okay, what are they?
First, the channels of interstate commerce, think highways, internet, waterways. Second, persons or things in interstate commerce goods being shipped, people traveling across state lines. And third, activities that have a substantial effect on interstate commerce.
And Lopez involved?
The Gun-Free School Zone Act. The court said possessing a gun in a local school zone wasn't really a commercial activity. And crucially, it didn't, by itself or even adding up all instances, have a substantial enough effect on interstate commerce to justify federal regulation under the Commerce Clause.
So that reestablished some limits. What about that aggregation doctrine, though? The idea that lots of small individual actions can add up to affect commerce. I always think of Wickard v. Filburn, the farmer growing wheat just for himself.
Right. Wickard is the classic example. That 1942 case said Congress could regulate his personal wheat consumption because if many farmers did it, it would impact the national wheat market.
So why didn't aggregation work in Lopez?
Because, as Angela's outlines explain, the court in Lopez, and later in United States v. Morrison, which dealt with the Violence Against Women Act, they limited that aggregation doctrine. They said it primarily applies to commercial or economic activities.
Ah, so growing wheat, even for yourself, displaces buying wheat that's economic, but possessing a gun near a school or gender-motivated violence.
Exactly. The court said those are fundamentally non-economic activities. So even if they might have some aggregate effect on the economy, you can't use the aggregation principle to regulate the underlying non-economic act itself under the Commerce Clause. It was a big shift, reasserting some boundaries.
Okay, moving beyond Congress, what about the president? The executive branch has powers too. Executive orders, military actions that must bump up against state authority sometimes, or individual rights. How does that fit in?
Definitely. The president's role is crucial. As commander-in-chief, the president has significant authority over military actions, often even without a formal declaration of war from Congress, especially if there's, hostility directed at the U.S. courts, tend to be pretty deferential here, often calling challenges political questions.
And treaties versus executive agreement.
Right. The president negotiates treaties, but they need Senate approval, 2/3 vote. Once approved, they have the force of federal law, binding on the states. Executive agreements, on the other hand, don't need Senate approval. They're still binding internationally, but domestically, they're subordinate to federal law and treaties.
And we've seen presidents recently use executive orders quite a bit, haven't we? On immigration, even things like homelessness. Those often face legal fights.
Yes, that's a major area of action and friction. Executive orders are tools for the president to manage the executive branch and implement policy without needing Congress to pass a new law. But they aren't unlimited.
They have to be grounded in the Constitution or a statute.
Exactly. Their legality is subject to constitutional limits, laws passed by Congress, and judicial review. We saw this clearly with challenges to things like the travel ban early in the Trump administration. Courts stepped in, required revisions. It shows the checks and balances at work.
And Congress sometimes delegates power too, right? Like
Right.
trade policy.
Good point. Section 301 of the Trade Act of 1974, for example, gives the president power to impose retaliatory tariffs. That's Congress handing over significant discretion, allowing the president to directly impact international commerce, which states obviously can't override.
What about things like executive privilege and immunity? How do those presidential powers relate to this balance?
They're important presidential prerogatives. Executive privilege lets the president keep certain communications confidential, mainly to get candid advice or protect national security, but it's not absolute.
United States v. Nixon, right, the Watergate tapes.
The key case. The Supreme Court said privilege exists, but it had to yield to the need for evidence in a criminal proceeding. Justice needs evidence.
And immunity. Can the president be sued?
Executive immunity, mostly from Nixon v. Fitzgerald, protects the president from civil lawsuits for damages related to their official actions while in office. The idea is to let them do their job without constant fear of being sued.
But not for unofficial actions or criminal charges.
Correct. It doesn't cover acts outside their official duties, and it doesn't shield them from criminal prosecution. The president isn't above the law, even with these protections.
Okay, let's swing back to the states. The 10th Amendment reserves powers to them. One of the big ones is the police power, right?
Absolutely crucial. The 10th Amendment recognizes this inherent police power of state governments. This is their broad authority to pass laws to protect the health, safety, welfare, and morals of their people and property within their borders.
So traffic laws, public health rules, zoning, education standards. Most of the day-to-day regulations we encounter.
Largely, yes, that's state police power at work. And importantly, it's a power the federal government generally does not possess, except maybe on federal land like military bases or in D.C. This difference really defines a lot of the state-federal dynamic.
So states are kind of the default regulators for everyday life, unless the feds have specifically been given power or have stepped into a field. That explains why laws vary so much state to state on things like, well, almost everything.
Exactly. States as laboratories of democracy, as Justice Brandeis famously put it, they can experiment with different policies.
Now, this idea of state sovereignty connects to the 11th Amendment too, doesn't it? State sovereign immunity.
Yes, they're closely linked. The 10th reinforces the idea of states as sovereign entities, and the 11th Amendment gives that teeth by generally barring private citizens from suing state governments in federal court for money damages or certain injunctions. Doesn't matter if it's their own citizen or a citizen of another state.
And didn't some cases extend that even further? Angela's notes mentioned Alden v. Maine.
Right. Alden was significant. It extended that immunity, saying states generally can't be sued by private parties in their own state courts without their consent either. And then Franchise Tax Board v. Hyatt confirmed immunity applies in other states' courts and even federal agency proceedings. It's a pretty robust immunity.
So suing a state is tough, unless the state agrees to be sued.
Which has to be a clear, explicit waiver, not just implied.
Or unless Congress abrogates that immunity. But you said Congress can only do that under specific authority.
Exactly. Congress can only override state sovereign immunity when it's legislating under Section 5 of the 14th Amendment. That section gives Congress power to enforce the guarantees of the 14th Amendment, like due process and equal protection, which were specifically designed to limit state power after the Civil War.
But not under other powers, like the Commerce Clause.
Correct. The court has held Congress can't use its Commerce Clause power, for example, to authorize suits against states that violate the 11th Amendment. So that 14th Amendment Section 5 pathway is crucial, but it's specific.
Okay. Another key 10th Amendment concept protecting states is the anti-commandeering doctrine. What's that about?
This is a vital check. It basically means the federal government cannot force state governments or state officials to enact or administer federal laws or regulatory programs. It protects the state's independence and political accountability.
New York v. United States is the go-to example, isn't it? The radioactive waste disposal case. Congress couldn't just order states to take ownership of waste.
Precisely. That case laid down the marker. Congress can't just issue direct orders to state legislatures. And then Prince v. United States took it a step further.
That was the Brady Bill case. Background checks for guns.
Yes. The court ruled Congress couldn't compel state and local law enforcement officers to conduct those background checks. It reinforced that the federal government can't commandeer state executive branch officials either, making them carry out federal tasks. Washington has to use its own personnel or find other ways.
But wait, what about Congress using its spending power? Like in South Dakota v. Dole, withholding highway funds unless states raise the drinking age to 21, that feels pretty coercive. How is that not commandeering?
That's the million-dollar question, and the court draws a fine line. Yes, Congress can attach conditions to federal money it gives to states. The test is whether the condition is clearly stated, related to the purpose of the federal spending, not violating other constitutional provisions, and, crucially, not unduly coercive.
So Dole wasn't coercive enough. Losing 5% of highway funds wasn't seen as forcing the states.
The court viewed it as pressure, maybe strong encouragement, but still ultimately a choice for the states. Accept the funds with the strings attached, or forgo the funds. It's framed as a conditional offer under the spending clause, not a direct command like in New York or Prince. It's a powerful tool, for sure, but constitutionally distinct from commandeering.
Okay, so states have powers, but they also have limits, especially when their actions might interfere with federal law or interstate commerce. You mentioned the Supremacy Clause earlier.
Right. Article 6, he says the Constitution and federal laws made pursuant to it are the supreme law of the land. This leads directly to the doctrine of preemption.
Where federal law overrides state law?
Essentially, yes. Preemption can happen in a few ways.
Yeah.
There's express preemption, where Congress explicitly says a federal law displaces state law. There's conflict preemption, where it's impossible to amend both federal and state law, or where state law stands as an obstacle to federal objectives.
And then there's field preemption.
Right. That's where federal regulation in a particular area is so pervasive and comprehensive that the courts infer Congress intended to occupy the field, leaving no room for state laws, even if they don't directly conflict. Think areas like perhaps nuclear safety regulation or immigration enforcement, where federal dominance is clear.
Okay, and beyond preemption, there's the Dormant Commerce Clause. That limits states even when Congress hasn't acted.
Exactly. It's dormant because it's an implied restriction derived from the grant of power to Congress to regulate interstate commerce. The idea is that this grant implicitly limits the state's ability to pass laws that unduly burden or discriminate against commerce flowing between the states. It protects the national economic market.
So states can't just pass laws that openly discriminate against businesses or goods from other states, like that New Jersey case banning out-of-state trash, Philadelphia v. New Jersey, or states trying to protect their own wineries.
Correct. Laws that discriminate on their face against out-of-state commerce are almost always struck down. They face really strict scrutiny. The state has to show it has a legitimate local purpose that absolutely cannot be served by any non-discriminatory means. Very tough burden.
What if a law isn't discriminatory, but it still makes it harder for out-of-state businesses?
Then the court uses a balancing test, often called the Pike balancing test. It asks, do the burdens the state law imposes on interstate commerce clearly outweigh the supposed local benefits the law provides?
Like the Illinois mudguard case you mentioned earlier.
Exactly. That Illinois law required curved mudguards, different from most other states. The court found the burden on truckers having to switch mudguards or avoid Illinois significantly outweighed the minimal, maybe even questionable safety benefit Illinois claimed. So it was struck down as an undue burden.
Are there any ways around the Dormant Commerce Clause exceptions?
Yes, the big one is the market participant exception.
Ah, right. If the state isn't acting like a regulator, but like a business?
Precisely. If the state is actually participating in the market, buying or selling goods or services, it can favor its own citizens or businesses, just like a private company could choose its customers or suppliers.
Like the South Dakota cement plant case. They could prioritize selling cement to South Dakotans.
Yes, Reeves Inky Steak. Because South Dakota owned and operated the plant, it was acting as a market participant, not a regulator imposing rules on others. So it could favor in-state buyers without violating the Dormant Commerce Clause. Big difference.
Okay, shifting focus slightly again. The 10th Amendment also mentions powers reserved to the people. This seems to connect to individual rights, maybe even ones not explicitly listed in the Constitution, right? Like through substantive due process.
Absolutely. That's a really important dimension. While the 10th is often discussed in terms of state versus federal power, that phrase, or to the people, reminds us about individual liberties. And yes, substantive due process, derived from the 5th and 14th Amendments' due process clauses, is a key way the court has protected certain fundamental rights from government interference, even if they aren't spelled out word for word in the text.
This is where things get controversial sometimes, isn't it? Protecting rights that aren't explicitly listed.
It can be, yes. Substantive due process involves the court identifying certain liberties as so fundamental related to privacy, autonomy, family, that government interference requires a very strong justification. Critics argue this allows judges too much leeway, essentially creating new rights. Supporters see it as essential for protecting human dignity and adapting the Constitution.
And a huge example recently was the right to marry for same-sex couples in Obergefell v. Hodges, wasn't it? That built on earlier cases about marriage and intimacy.
Obergefell is a prime example. The court explicitly linked the right to marry to fundamental concepts of liberty, dignity, and autonomy protected by the Due Process Clause, extending it to same-sex couples. It drew on cases like Loving v. Virginia, interracial marriage, and Lawrence v. Texas, intimacy.
It recognized marriage as evolving, and denying it demeans same-sex couples.
Right, but it definitely sparked intense debate. The dissenting justices argued forcefully that the Constitution says nothing about same-sex marriage, and that such a change should come through democratic processes, like state legislation, not court rulings. It really highlights that ongoing tension over judicial review and unenumerated rights.
And related to protecting people is the Equal Protection Clause of the 14th Amendment. If the government treats groups differently, it needs a good reason, right? This involves different levels of scrutiny.
Exactly. Equal protection analysis kicks in when a law draws distinctions between groups of people. How closely the court examines that distinction depends on the type of classification being made or the right being affected.
So you have strict scrutiny, intermediate scrutiny, and rational basis review. Strict scrutiny is the toughest standard.
It is. The government has to prove the law is narrowly tailored, the least restrictive means to achieve a compelling government interest. It's a very high bar, usually fatal to the law.
And that applies when?
It applies to laws that classify people based on suspect classifications like race, national origin, or sometimes alienage, or when a law infringes on a fundamental right, like the right to vote or travel interstate.
Intermediate scrutiny.
That's the middle level, usually for classifications based on gender or non-marital parentage. The government has to show the law is substantially related to an important government interest. Still demanding, but not quite as high as strict scrutiny.
And rational basis is the default.
Pretty much. For most economic regulations, social welfare laws, classifications not deemed suspect or quasi-suspect, the law just needs to be rationally related to any legitimate government interest. It's very deferential to the government. The challenger has a heavy burden to show there's no conceivable rational basis.
So the level of scrutiny really depends on the constitutional value the court puts on the right or the classification.
That's a good way to think about it, yes.
What about some of the less famous amendments? Do they ever touch on these reserved rights or state-federal issues? Like the Third Amendment, quartering soldiers seems pretty obscure today.
It is rarely litigated, true. The Third Amendment prohibits quartering soldiers in private homes without consent in peacetime. But interestingly, it has been cited by some courts, like in England v. Carey, as contributing to a broader constitutional right to privacy, reinforcing the sanctity of the home from government intrusion. That case also incorporated it against the states through the 14th Amendment. So even obscure clauses can have resonance.
And the Eighth Amendment, prohibiting cruel and unusual punishment and excessive bail. That seems very relevant today, especially with prison conditions and issues around homelessness.
Extremely relevant. The excessive bail clause, as interpreted in Stagg v. Boyle, aims to ensure bail isn't used punitively, just to ensure the accused appears for trial. But the cruel and unusual punishments clause has generated a huge amount of litigation.
Regarding prison conditions.
Yes, the court has held that conditions of confinement violate the Eighth Amendment if they involve the unnecessary and wanton infliction of pain or result from deliberate indifference by officials to inmates' serious health and safety needs.
And the homelessness connection. Martin v. Boise.
Right. That Ninth Circuit case held that punishing homeless people with civil citations or criminal penalties for sleeping outdoors when no shelter is available essentially criminalizes their status and constitutes cruel and unusual punishment under the Eighth Amendment.
So laws just banning sleeping in public could be unconstitutional if there's nowhere else for people to go.
That's the core argument, yes. It connects to broader concerns about vague anti-loitering or anti-camping ordinances potentially being used to punish people simply for being visibly poor and unsheltered, raising serious Eighth Amendment questions about punishing status rather than conduct, especially when the conduct is unavoidable due to lack of alternatives. It's a really active and complex area of law right now.
Wow. Okay, we have definitely covered a huge amount of ground today on the 10th Amendment and its ripples throughout constitutional law, from federalism basics to commandeering to unenumerated rights.
Yeah.
It touches so much.
It really does. It's fundamental.
And thank you so much, Angela, for sharing your incredibly detailed common law notes with us. They were seriously invaluable in guiding this whole discussion.
Absolutely. Couldn't have done it without them.
Yeah.
And just a few reminders for everyone listening as you hit the books. First, remember Angela is a law student, just like many of you studying for the bar. She's worked hard on these notes, but she's not an expert yet, and she hasn't passed the bar herself.
Right. And second, super important, neither Angela nor this podcast is giving legal advice. Nothing we talked about today should be taken as legal advice for your specific situation. Think of us, the AI, as a study aid, maybe helping clarify concepts, but definitely not a shortcut or replacement for your own hard work.
Exactly. This podcast is meant to supplement your learning, give you another angle, but it absolutely shouldn't be the only way you're studying. And remember, AI isn't perfect. Sometimes we might make mistakes.
True. Angela does try to double-check everything in her notes, but even the best law students can miss something or make a mistake occasionally. Always verify with primary sources and your main bar prep materials.
And finally, just to be clear, this podcast episode and the whole series is an academic, non-commercial project by Angela. It's strictly for educational purposes.
Right. Helping fellow students out.
And one last practical tip. If you are listening while driving, please be safe. Focus on the road. Don't cause a tort while listening to us talk about constitutional law.
Haha. Good advice. Okay, so if you do need to contact Angela, the email is podcast@studyforthebarinyourcar.com.
And if you are an attorney or know one who could use help with legal research, drafting motions, complaints, appeals, etc., Angela does freelance remote law clerk work.
Right, you can reach her for that at hello@legalwriterandlawclerk.com.
Okay, so Before we wrap up properly, I believe tradition dictates it's joke time.
Yeah.
Do you have a cheesy 10th Amendment joke prepared?
You know I do. Okay, ready. Why did the federal government get a ticket on the highway?
I don't know. Why?
Because it was exceeding its enumerated powers.
Oh boy, classic. Okay, well, we'll see you all in the next podcast. We'll be diving into the 11th Amendment next time. That's the one protecting states from certain lawsuits.
Looking forward to it. This is Maude
And Claude, your AI host.
signing off.